Good afternoon. This is Julie Finlayson from the Centre for Native Title Anthropology at the ANU. And this is the second workshop of two that we have held with Justice John Mansfield, talking to anthropologists about the kind of roles and work that they can take on in compensation claims. This workshop was held on the 16th of September 2020 in a Zoom format. John begins his discussion by reviewing some of the key points from the first workshop, and then he goes on in this second workshop to discuss the challenges anthropologists will face and the kind of roles that they can play. Following John's discussion, David Martin also looks at the roles of anthropologists, but starts by looking at the High Court's judgment on cultural loss and its implications for anthropologists. And then he turns to the issue of what mutual and respective roles anthropologists and lawyers together and separately will play in the compensation work. In this second workshop, we have ensured that the PowerPoint material used to illustrate various points both John and David have made are now integrated into the recording. So this is not simply a podcast, but more of the recording of the full Zoom workshop for your instruction and enjoyment. Thank you.
Okay, well, welcome all again. Thank you for the chance to have another discussion about what is a very, very important topic and something that we all have a lot more to learn about. I thought we'd start just with a little recap, which Tegan is going to manage through the system. I don't want to say anything more about this screen except to remind you of where I started when we were talking about this last time. That is the fundamentals of what the right, or how the right to compensation arises. You will remember that it is only really since the Racial Discrimination Act, which came into force in October 1975, and then that the issue as to the compulsory acquisition or the taking away of Indigenous rights, which the common law recognised, became compensatable, because until that time there was no legislation which the Commonwealth had enacted which could give that right. So that's really why we're focusing on acts which adversely affect native title rights and interests from 1975. And there are slightly different regimes depending upon the three periods of time after that. I don't think that's ultimately much is going to turn on that. But that's the fundamental starting point. And from that, if we go to the next screen, we then discussed last time the case of Timber Creek for obvious reasons, a case which I had the privilege of deciding, and which went all the way to the High Court. And if I can just remind you of it, there were three broad issues in the Timber Creek case. The first was the step of saying when land is taken away or rights are taken away from the enjoyment of land without compensation after the Racial Discrimination Act, the Native Title Act gives you the right to compensation, and your starting point is the economic value of the land taken away. That is the same as any other compulsory acquisition of land in Australia under Commonwealth legislation or under state legislation. So that was really a separate dispute to work out, because of this land that was taken away in the township of Timber Creek, what it was worth had it been compulsorily acquired. And that involved, if you remember, a complex issue, because if you compulsorily acquire land, you take away the lot. And so the land, what might be called just the real value of the land, at the time to any person is the starting point. In the case of native title rights and interests, because they have progressively, in some circumstances, been removed, and we're all familiar with the exclusive and the non-exclusive native title rights and interests in Australia under Commonwealth legislation or under state legislation. So that was really a separate dispute to work out, because of this land that was taken away in the township of Timber Creek, what it was worth had it been compulsorily acquired. And that involved, if you remember, a complex issue, because if you compulsorily acquire land, you take away the lot. And so the land, what might be called just the real value of the land at the time to any person is the starting point. In the case of native title rights and interests, because they have progressively, in some circumstances, been removed, and we're all familiar with the exclusive and the non-exclusive native title rights and interests, by the time of the compensatable acts in Timber Creek, and probably in most cases now, the native title rights and interests will not involve exclusive native title. They'll involve some lesser package of rights as they're defined or described in the Ward case. So non-exclusive native title was said to be worth 50% of the freehold value of the land. I'm not sure that will be a routine step to take, but it's not something that we really want to talk about now. It's something that will no doubt be explored in the future. The second thing that Timber Creek talked about then was how much compensation should be awarded for the loss of those rights, either freehold or part freehold value. And again, we don't, the interest on that loss was calculated from the date of the offending act, of the compensatable act. And there was a dispute in that case about whether it should be compounded or simple interest. On the facts, that was found to be simple interest. And that, again, that's something which the lawyers will look at each time they have a compensation case, and may involve the anthropologists in considering certain aspects of that. The reason that they might involve anthropologists in that is because under the Australian common law, the law which we all operate under, if a damage is caused to you, you're entitled to the amount of damages assessed at the time of the injury. That sometimes involves prospective loss, and so you don't get interest on prospective loss until it would have been occurred, and it often occurs prospectively because, for instance, a loss of earning capacity involves a loss over a lifetime of working. So that does give rise to difficult questions. And the other thing that interest is calculated on, if it is to be compounded, is for the person who suffered the loss to have proved that but for the loss being suffered, the money that was the value of that loss would have compounded itself. So if you were running a business, you would try and prove that if you'd had the money at the start, you would have used it in a certain way which would have produced a much greater loss than if you'd simply put it in the bank at what is now about 0.55% interest. So that's why that was an issue in that case. And the third step was the cultural loss. And that was the step which I think was the most significant. It was the step which throughout the initial judgment, the full court and then the High Court, the same number was adhered to and found to be appropriate. And ultimately, there was no errors found by the High Court in that process of reasoning. So that's what we're talking about, the description of cultural loss and the role of anthropologists in assisting in its quantification. That, as a separate element of compensation, was clearly recognised by the High Court, and it was an issue which was argued before the High Court after the decision, both at first instance and in the full court. In the High Court, the Northern Territory said, in effect, that because you were really compensating for cultural loss, which was non-economic and was consolation for the distress upon being taken out of the country or the rights to country which you enjoyed, it had no monetary value at all. That was rejected. It was secondly argued that because there could be what was sometimes called indirect loss or collateral loss, there was an inability to get compensation, because if a particular block of land was taken, you could not get loss because that affected the way in which you could use or not use an adjoining block of land, and that was also rejected. And then it was said by the Northern Territory that the amount of money was much too much, and that was rejected. The Commonwealth took a somewhat more moderate stance, but looked particularly at two things. One is that it was not appropriate to quantify cultural loss by reference to the indirect or consequential effect upon the enjoyment of related land and related activities. And secondly, that it was just too much. And again, those matters were rejected in the High Court. So the High Court then said that cultural loss is compensatable. And there are a couple of things I wanted to draw from that, which I've got noted in this screen. And I'll come back to these when we later on have some questions and discussion at perhaps the end after David's made some comments. Cultural loss is a very difficult concept to grasp hold of. The claimants are the native title claim group, not individuals. But the High Court grappled and accepted the very difficult concept of saying that although the loss is a contemporary loss, because that is what the Native Title Act provides to be compensated, it must be measured having regard to its impact upon the community, including the recognition of what the community could or could not, or might not be able to do in the future. And that's a very important thing to understand, because the Native Title Act does not say the compensation is the compensation to an individual or a group of individuals as individuals. It is a community compensation. You have to think about that a bit, because it's quite a difficult line to draw when one's playing with that. Just a couple of passages that I wanted to draw to your attention from the High Court decision about that. The High Court said, I'm just going to, towards the end of the judgment of the 5 majority judges, although the description of the native title holders was an agreed fact, the High Court went on to say, and I'm looking at paragraphs 229 and 230 of their judgment, was a description that enables the composition of the group to be determined from time to time as the composition of the group changes, as senior members die and new members are born. And it was because of this change in composition that the entitlement to compensation is a communal or group entitlement, which is of particular significance when assessing the effect of the compensable acts on cultural loss. And it was therefore appropriate, as was done at first instance, to treat the loss as permanent and intergenerational. That's the term which was used. So when we're assessing cultural loss, the evidence will have to be sufficient to show to the judge how that loss will impinge, has impinged in the past and will impinge in the future. That's a very difficult and interesting anthropological exercise. And I'll come back to that just in a minute. That leads, I think, to something which will require attention in the future, because although it is a contemporary loss which is being quantified, there must, I think, be at least some concern about the accountability for that management of and application of the compensation. We've all come across some communities where there is a very strong individual or group of individuals who are quite dogmatic about how funds which are received to be applied, and which may not be, at least from the outside, appropriately applied, having regard to the long-term interests of the community. That is, the intergenerational and future generations of that community. I think I mentioned last time in Timber Creek, the bridge which was permitted over the Victoria River by this same community to enable the army to take the Bradshaw Fields, Army Field. And they put the bridge over and they agreed upon a figure for compensation, which I think the evidence said was about 300th of that number, but it appears in the judgment. And the seniors of that community were asked, well, what did you do with it? Well, we spent it. That's okay. It may have been an entirely appropriate thing to do, but they split it amongst themselves and spent it probably on for community benefit. But where we're going to be talking about very large sums of money, I simply raise for another occasion issues of accountability, transparency, and how the future generations, or the next generation or the one after that, or indeed current generations, current people within a community might have a say or might have a concern about the use and application of funds which are received. So that's what the little word accountability carries with it, just a teaser. And the third thing is covered by the three next dot points. The Borroloola case was the first case in the Northern Territory in which the Northern Land Council, on behalf of the claimants, asserted a right to trade as one of their native title rights and interests. And it was a very hotly contested right. Borroloola, you probably know, is in the southwest corner of the Gulf of Carpentaria, and the claim group enjoyed native title rights in that vicinity up to the water's edge in the Gulf of Carpentaria and in the islands which are in that southwest corner called the Sir Edward Pellew Group. And the evidence was that at least for 100 years, and that's as much as people could remember, so probably longer than that. When I say remember, there was some documentation of it as well, going back to the late 1880s. They had traded with the Macassans. The Macassans would come down through the Gulf and they would trade some trepang. They allowed the Macassans to take trepang from the seas, and they would trade their products between the two or swap them, so that there was some quite clear evidence of the right of trading. And there was a very vigorous anthropological dispute in that case about whether that could be a native title right and interest to be able to trade. Because one of the anthropologists took what might be called a purist's view of saying, well, that might have been what they did, but it wasn't a tradition pursuant to traditional laws and customs, because originally traditional laws and customs did not have that right. And that led to quite an extensive examination of trading rights in and between Aboriginal communities in the northern part of Australia, and indeed over much of Australia, for much of documented history. And the finding was that that right to trade did exist. And I think it has now been recognised that there was no appeal from that finding in the Northern Territory, and is now included in almost all of the consent determinations. So, having made that finding, the native title rights and interests included, in that case, what might be called a commercial right to trade. Is the loss of the commercial right to trade something which is to be taken into account in determining cultural loss? And that isn't a silly question. If I'm running a business and my business is taken away, the value of the land where I'm running the business on, assuming I own it, is probably represented by the value of what I could earn out of that business, because the standard starting point is that you take the highest and best use. If your land is being acquired by the government, they have to concede to you the highest and best use. If it's trading, running a factory, that's that. If it's running a shop, that's that. If it's residential, if it's high property development, whatever the highest and best use is what they use. So the right to trade in certain circumstances might be part of the highest and best use of the land for the purposes of fixing the first compensatory step, the economic value of the land acquired or the rights acquired. It might not be, because as the High Court said, when you come to look at compensatory or compensation claims, the Compensatory Act has to take place after 1975. And in different communities, the level of connection with the land of the Indigenous group will vary from place to place and from circumstance to circumstance. And in some cases, as in Timber Creek, it was a very close and hard, tight connection. In other places, I can take Martin Place, Sydney, as an example, it would be a very slight connection, simply because the people, by 1975, the traditional owners had been so effectively kicked off the land, and it had been so effectively taken from them, they had probably lost that sense of connection with the country, which was more apparent in the Timber Creek case, because they were still living on the country and still practicing their rights and interests on the country. So it's an interesting question. Just a little teaser in that. I might move on then to make a couple of points before I get David to make some comments. The next screen, which I wanted just to make a few comments about, is this: going back to basics. It is very common in litigation to call an expert witness, and it is not uncommon in litigation, particularly in criminal litigation, where there's originally challenges to fingerprints evidence and then challenges to DNA evidence, now challenges to a lot of other techniques, to challenge the entitlement of the expert to give evidence at all. In the case of anthropology, that battle has obviously been conceded many, many decades ago, but it's worth just reminding ourselves of what an expert is for the purposes of giving evidence. An expert in evidence involves two steps. Firstly, there must be a body of scientific or social expertise which the community recognises is capable of being acquired by an appropriate process of study or experience. Now that's anthropology to a T, so it's not a contentious issue. And the second thing is that the person proposing to give evidence must then show that that person has that expertise by appropriate study and experience. And then you can let the expert give evidence. It's still quite common for there to be challenges to certain types of evidence. An obvious example for you would be if a lawyer said, well, You're an anthropologist. You know how closely this community was existing, how long that existed, how much they valued this, what their practices were. How much do you think it's worth? Because the study of anthropology does not include the quantification in economic terms of that sort of thing. That's left to the judges. There is no, I mean, there might be a study of anthropology that lets you answer that, but I've never come across it. And it's quite common, you know, if you have an expert in, or a purported expert in some scientific topic. I remember one expert witness came along and said, I'm an expert in the behaviour of steel in car accidents. You know, how cars crash together and you can tell who was going faster and who was going slower, and I'm the expert in that. And there is a thing called a voir dire, which is simply to see whether you're allowed to say it. So there was a question of this person to see whether they were qualified to do this, and they said, very unfair, what's the linear coefficient of steel? And I don't know how many of you can answer that, but we all vaguely remember it from school. But this bloke said, hello, I don't understand your question. And it transpired that he was a pretender. So as soon as it was, an experience was taken by using basic knowledge in the area of his claimed expertise, it was demonstrated that he didn't have the expertise which he professed. So there will be occasions, I guess, when anthropologists will be asked questions which someone might say, look, we acknowledge that there is anthropology. We don't acknowledge that this person is entitled to say or answer that question. All of you have had some experience in archaeology, in linguistics and in history. But there may be questions touching on those particular areas of expertise which are marginal to your expertise and where there will be an objection. So when you come to think about what you can and can't say, or what you should or shouldn't say, it's always important to go back to what is my fundamental training as an anthropologist? What is the profession of anthropology about? Do I have an additional training or expertise in another discipline, such as linguistics? And then to deal with the answer, or you might say, look, that is a bit outside my area. You really need somebody else to deal with that. I know about archaeology in a certain way, but I'm not able to tell you the age of that stone because that's the expertise of someone else. I merely mention that because I think lawyers will be asking you to push the barrow a bit, push the envelope a bit, because it is such a difficult process to fully comprehend and convey the nature and extent of cultural loss. I wanted to end, if I could, just with the next screen, the novice judge. And the reason I've got this here is simply because it's something which I remember writing in the first disputed native title case I did. This Aluwara case was in the Davenport Ranges, which is about 200 kilometres southeast of Tennant Creek. So it's very remote country, and a lot of the evidence was given on outstations. And we had some wonderful anthropological evidence there. We almost killed an anthropologist there, actually. On the first day of the hearing, we were at an outstation and there was a tent put up with one open side and three corners. And because of the three corners, there was one set of lawyers on one side, another set on the other side with their clients to a degree, and then me at the back in the middle. And sitting outside, there was one big area where the women were sitting and another big area where the men were sitting. And it was all tightly banged down with star droppers. And we were sitting there very soon after. And if you're looking from the judge's point of view towards the tent, it was on the right-hand corner, right on the corner. The anthropologist called by the Northern Territory was sitting. His name, you will all know, is Basil Sanson. You know Basil well. I'm sitting there and I can see this whirly coming along through the dirt. towards the tent, and it wasn't particularly a demanding whirly. It was just a sort of a whistle of dust swirling around and around. Got to the tent, and for some reason, the star dropper was loose, and it pulled up the star dropper, and it went up in an arc and came down and, with the sharp pointing end, landed in the desk in front of Basil, about 3 feet from his face. And had it been a little bit different, it would have done him a very severe injury. So that was, apart from anything else, made the federal court a lot more careful about how it put tents up. Anyway, that's this little passage here is simply me saying, as a novice judge, with the benefit of the anthropology there, how much help I was able to get from it and the various angles that the anthropological evidence was able to give. Anyway, having made those comments, we did have some discussion about anthropologists and lawyers and how the role of anthropologists can best fit. We're all going to learn that, but David Martin has very kindly put together some thoughts about that, and subject to you, Julie, I'm happy to hand over to him unless there's some pressing questions before we do that.
This presentation, relatively short, is at a reasonably high level of abstraction. It's not going into the kind of detail that, for example, Kingsley Palmer's talked about and written about in terms of the kinds of matters that anthropologists may need to cover. It's an attempt to look at this discussion, this presentation of cultural loss in the Timber Creek High Court decision, and to think through the implications for how we anthropologists may, the kind of particular arenas that we may need to work in. And it's also looking very much at something that John Mansfield mentioned, and that is, what does it say about how the lawyers and the anthropologists in a given matter are to work, and including work together. And as you'll see in this presentation, I think it throws up some real challenges to the way that we've been working, especially those of us engaged as experts, on the one hand, and the lawyers who brief us on the other. So if we could go to the first slide, thanks, Tegan. I thought it useful in considering this to go back again to what native title is. And this is a diagram which largely, it has its origins in some comments to me a long time ago by Noel Pearson, in fact, and he now disavows this view of native title. And also in a book written 2 decades ago about PBCs by Christos Manzaris, a barrister, and myself. And we saw, that was in 2000, we saw native title very much as lying in, firstly, a recognition space, because while it is recognised by Australian law, it has its origins in each case, that particular system, as the Act calls it, of law and custom, under which people had connections to country, which give rise to those rights and interests. So it is not necessarily, and this is a really important distinction, the rights, the native title rights and interests may or may not be directly elements that are explicitly of that form in that particular system. In fact, very likely they won't be. What they are, though, is, we argue, a translation from that system of connections under law and custom into something which is, we use the term cognizable to, able to be accommodated by and recognised by Australian law, most particularly property law, which, and I stand to be corrected by you lawyers present, deals with the relations with property as, in essence, a bundle of rights. And that's what native title is. It's a bundle of rights and interests recognised by the Australian legal system, having their origins in the Aboriginal system, but a translation. And I'll come back to that translation shortly because it's a crucial element. Can I have the next slide, please? So, as John was saying, and as the little handouts on the ERA claim showed, it's long been accepted that anthropologists have a role in providing expert opinions in the matter of connections to country, as part of the whether we're dealing with a connection report or indeed an expert report. What is not necessarily, what is not now challenged is that anthropology at least has the expertise. There'll always be given opinions which are challenged, but that's accepted. I'll come back to mention that towards the end of my presentation. And as I said, Christos Manzaris and I in 2000 portrayed this as both a recognition space and as a translation space between, in essence, two different systems of law. The High Court, in its the Timber Creek majority decision, and it was drawing then on that earlier 2002 Ward High Court decision, referred to the difficulties inherent in expressing this relationship between a native title group and its country in terms of rights and interests. And I'm going to read here, I think it's a really useful expression here. Yet that is required by the Native Title Act, that is, this translation. The spiritual or religious is translated into the legal. The difficulties are not reduced by the inevitable tendency to think of rights and interests in relation to the land only in terms familiar to the common lawyer. And what they're saying there, in essence, is that native title rights and interests may be a rather, and very often are, an impoverished translation of that system into rights and interests. So while, another point which I want to come back to, while it's been seen as legitimately the role of anthropologists to give expert opinion, write expert reports on the nature of connections that the particular group has with its country, that of actually establishing the native title rights and interests has always been seen as largely the provenance of the law. And sometimes, in fact, you see that in very, very starkly when a native title claim is lodged and a lawyer will draw up the rights and interests well ahead of any ethnographic investigation into the connections of that particular group, particular claim group. More and more, they've tended to become formulaic, although, again, as John Mansfield was saying earlier on, the notion of what can be encompassed in rights and interests is moving with the jurisprudence, so now that it can include the right to trade. My original view was that the matter of rights and interests should be absolutely that of the lawyers. It should be left to the lawyers. I resile from that more hardline view. It's one that's been expressed in an article by Robert Blau's senior counsel. But I think it entails, at least ideally, more of a collaboration than just being simply the work of lawyers now. Can we go to the next slide, please? Another important matter, I think with quite a lot of implications, is that the decision that the majority High Court decision emphasises the fundamentally spiritual and metaphysical nature of Aboriginal connections to land, and indeed drawing in part on the trial judge, and I give a section there, 197-206 in the High Court decision. It referred earlier, later to the finding of the full federal court, and I think this is worth also reading directly. Assessment of the effects of the compensable acts for cultural loss could not be divorced from the content of the traditional laws and customs acknowledged and observed by the claim group. So here and elsewhere in the High Court decision, the locus of cultural loss seems to lie largely, if not entirely, in the arena of impacts on the connection itself, the connection of that group to its country. under its laws and customs. In other words, if we were to follow this, cultural loss involves a focus on the matters which have been the bailiwick of anthropological work in the native title arena, which is connections under law and custom, to use the legal terms. However, at a number of junctures in the High Court decision, the decision refers to the impacts of the compensable acts on the actual native title rights and interests themselves. Could I have the next slide, please? And I'll give it just a couple of examples here. Your own reading, you'll find examples of all of this, but this is just rating some. So, for example, in 200, it refers to, again, the trial judges, John Mansfield's observation that, quote, prior to the compensable acts, there had been a progressive impairment of native title rights and interests, but that the compensable acts did not remove all of the claim group's native title within that area. And again, the High Court in other places, drawing on the trial judge's decision, they referred to each compensable act affecting native title rights and interests with respect to not just a particular tract of land, but also to the whole of the claimed area. So there, I'm not so much focusing on this very important issue of it's not just the localised impacts, but indeed the whole of the claim area. That wonderful analogy of the picture being punctured in certain places, and the damage to the picture is not just to be concentrated on in terms of those where it's been, punched through by something. My point there is they talk about the rights and interests again. So I think in summary, looking through that decision, in the matter of compensation, the High Court would have used connections and native title rights and interests essentially interchangeably, despite the fact that, at least as I see it, and as I think the court sees it, the rights and interests being a translation of that system of connections by which to country which people have. Nonetheless, both of them seem to be involved in discussions of the impacts of compensable acts. The next slide, please. So what can we draw from this? That is, what can we draw from, firstly, the matters I've just been talking about? That is, it's that the focus of the court has been very much on the cultural loss in terms of the impact on the connections, that is, how that system itself understands those impacts. But it's also constantly also referring to the impacts on rights and interests, native title rights and interests, and also that this is a translation, that the rights and interests are a translation of that system into a form which intersects with, is cognizable to, especially our property law. So the High Court stated this, and I'll read it. The task required by section 51.1, that was mentioned in the earlier podcast by John Mansfield, it's an absolutely fundamental section from which the power to compensate, the requirement for compensation arises. As the subsection itself recognises, requires a number of separate but interrelated steps. Identification of the compensable acts, identification of the native title holder's connection with the land or waters by their laws and customs, and then consideration of the particular and interrelated effects of the compensable acts on that connection. So that statement is unequivocally just focused on connection rather than rights and interests. But anyway, and that is, as I say here in the slide, the locus of determining the nature of cultural loss appears to largely lie in the laws and customs. But, as I've noted in a number of junctures, there are many places in the discussion on cultural loss where they also talk about the impact of compensable acts on the rights and interests themselves. Next slide, please. So I looked at this, developed this as a way of thinking through, well, what are the steps as is mentioned in that section from the decision, and who's responsible for them. The first is the identification of compensable acts. And there I said lawyers, but as all of you who are actively involved in these matters know, it's actually not just lawyers. I should have also added all kinds of other specialists, including GIS database developers, people who have got the ability to forensically go through land records. I would think historians, all kinds of people. But it's very much in the bailiwick of the lawyers in a sense, I think. So I'm proposing to pull these things together to define what are the compensable acts given given the High Court decision, given the introduction of the RDA, and so forth. What are the compensable acts in a given matter? And then we've seen, it seems accepted by the High Court, certainly the wide view, it's certainly what we anthropologists understand to be the case and what we do. Connections and what the High Court decision calls particular and interrelated effects on them are very much our bailiwick. That's the bailiwick of anthropologists. But the High Court also seems to be saying that compensable acts on the connections, law and custom, the what we might call the emic view, the view of people themselves. It also seems to be saying at a number of junctures that it's the impact of compensable acts on native title rights and particular and interrelated effects on them. And that may well be a matter for us to discuss and for lawyers to contribute to. And then, as a result of that, then there is a quantum given to compensation, which seems to me to be the work of lawyers themselves. What I'm suggesting here, though, is that there seems to be a quite different relationship, certainly in the cultural loss arena, between lawyers and anthropologists than that's required in native title claims themselves, most particularly those specifically in litigation where expert reports are prepared for, litigated proceedings in the court. There is a very strict distinction made between the work of the lawyers, the advocates for a matter, for a particular position on the one side, and the anthropologists as the experts, as independent, as in a sense, friends of the court, I suppose, who must consider all the information and come to a truly independent, at least ideally, view. If we're just looking at the impact on native title rights and the particular and interrelated effects on them, however, if I view that certainly lawyers, possibly lawyers and anthropologists, should be involved in that translation process, which is what it amounts to, into rights and interests, then the logical entailment would seem to me to be that they both need to be working together in the question of at the very least, that aspect of compensable acts. Query about connections as well. And I want to come back to that with some of the kind of challenges it sets out. So it certainly seems to me to be, there's the potential there for a rather different kind of working relationship between lawyers and anthropologists here than in the classic kind of litigated separation between the expert and the advocate. Can we go to the next slide, thanks? So a matter which independently, I think this is a good indication, independently raised by John Mansfield and myself, the question of what I've called here non-spiritual aspects of laws and customs. For example, what are those aspects of law and customs which give rise to the native title right to not say take resources, but perhaps specifically to trade? Is that one that's to be characterised as arising from that kind of deep spirituality and metaphysical almost relationships between Aboriginal people and country that was accepted and referred to by the High Court majority? how does a spiritual and metaphysical relationship give rise to trade? I'm not saying it doesn't. What I'm saying, though, that we should not confine ourselves just to those elements, but to look at not so much the native title right to trade, but what is the arena of the lives of people, for example, in the classical system, such that there was trading. The kind of thing, again, that was mentioned by John in relation to the Borroloola claim itself. So it seemed to me that that raises some interesting issues for us anthropologists and should steer us to not just confine ourselves to spiritual and metaphysical matters, shall we call it, that in terms of connections to country, but thinking through how those things also link into matters such as trading in the past and its contemporary manifestations. Another arena I wanted to focus on very much, again, was raised by John in his presentation just before. The High Court observed at 231 that a trustee PBC has statutory function to, quote, hold, invest and apply the compensation. And the High Court observed that it's no business of the court to determine how funds were to be spent. That is the intramural thing. The intergenerational matter that John raised. I myself have a firm view. I presented about it in an earlier podcast I've written about it, that anthropologists have roles not just in the connection side of native title, but also in the corporate design, the design of the PBC as a corporation itself, and also the way in which the PBC both carries out its obligations to consult with native title holders who may be impacted by a particular development on their lands under the PBC regulations. This is that anthropologists should be involved in that, and I've long been of the view that in relation to PBCs, the absence of anthropologists from the design, the absence of attention given to how these organisations are going to function, not just in terms of delivering their statutory obligations to hold or manage the native title and to consult and get what you could call loosely the informed consent of relevant native title holders, but also where they are trusts holding potentially very significant sums of money, the governance of that interface between the corporation and the group itself. It's an area where anthropologists, our ability to understand political and ethical nature of the groups with whom we work, the implications of, for example, localism on ethical frameworks, the intense commitment, and this is one example of the ethical frameworks, the intense commitment to immediate kin, which is above, places a much higher onus on the individual than a notion of the wider common good of the group as a whole. Anthropologists are well placed to understand these things, which I think by and large lawyers are not. And space that we have vacated or not been allowed to occupy, I think to the cost of the, let's call it the PBC landscape, and it's going to be even more significant in compensation claims where PBCs are the trustee for what could be quite significant sums of money. Next slide, please. So, and then the last matter, you'll be pleased to know, is I just want to make some observations that are in an earlier presentation. It was to the, I think to the annual conference, so the beginning of this year, on the notion of culture. Interestingly, it went all the way to the High Court And the same judges as had made the decision in the Timber Creek claim on cultural loss were also the judges there. And in my presentation, I looked at the difficulties faced by anthropologists in presenting the concept of culture and by challenges to anthropological methodologies from the law's more positivistic framework. In a nutshell, and I won't go into great detail here, it was a trader at the bottom of the APY lands. He ran a book-up service. It was deemed to be unconscionable. It was, there were highly problematic practices. The original trial judge found that it was exploitative. But my role had been to, in essence, to present evidence and opinion as to the vulnerability. What were factors that led to vulnerable people, in this case, being vulnerable? And I looked at I did both what I called a socio-cultural analysis and a socio-economic analysis. Next slide, thanks. And the court, by and large, a number of the judges took no notice of what I said before, but others, and I'm not saying they were wrong, but others did, and in fact, others used the sociological notion of agency, what to explain why people might make themselves very vulnerable, but still continue to shop from this gentleman's store. They actually used that without any of the other kind of analysis around the fact that, yes, people were exercising agency by making choice, but they were the choices they made were limited by a whole set of economic and social and let's call it cultural factors. And so they, from the point of view of the anthropologist, they bricolaged elements from it to arrive at a particular distinction. And what I said was that on my experience in that case, and indeed another one before yourself, John, the Kesho case, quite a long time ago, brought by the ACCC in a similar kind of exploitation, that outside of native title and the accepted place of anthropology in the matter of connections to country and laws and customs, outside of that arena, we have no protection for the views that we advance on matters which are not necessarily seen to be in the legitimate bailiwick of anthropologists. Like the one that came up was statistics, or at least hard data. What expertise does the anthropologist have around that, for example? And so there was a whole set of things that came up. Standard anthropological methodologies, like, for example, inductive reasoning, that is, that from the more particular to the general, to making generalizations, may and were directly challenged in the court by counsel and indeed found to be wanting by judges themselves. As I said, courts may pick and choose from elements of our accounts. And I've said here it's all the more necessary to provide systematic and interlinked expert evidence to try and counter that. But I have the sense that because precisely this is very much a greenfields arena, cultural loss, it is both the challenge and the opportunity for anthropology to expand from just the connection focus, but it's also a challenge in the sense that we will have to be extremely careful how we set out and legitimate our expertise to come to the views and provide an extremely clear process of reasoning, which must be specifically anthropological reasoning based on training, or the other one, I guess, is experience. And I think it's going to, there will be likely less benign acceptance of the role of anthropologists in some aspects. So I'll finish with that. Thanks.